I'm thrilled to let you know the Supreme Court is back in session, and while I tried to hide from this reality in my crawl space this morning, it didn't change anything. So we got to talk about it. In this term, the court is going to decide some massive cases, but I want to focus on one. And please remember, these cases are not decided yet. Justices are humans too. They can actually be influenced by public opinion, so let's use that. Now, as we think about cases facing the Supreme Court, I think some of their biggest decisions are going to invoke the major questions doctrine. The major questions doctrine is a system of logic put in place by conservative justices as a way of drawing the line in the sand for the bureaucracy. And that line can't be crossed by any federal agency or department without explicit legal authorization from Congress. And this line is defined as any action with vast economic or political significance. The conservative justices put this doctrine into place because they believed that under Democratic administrations, the federal government was getting too powerful. They believed federal agencies were reading between the lines in existing laws and assuming powers that they didn't actually have. Ironic, huh? Antonin Scalia described it by saying when Congress passes laws, they don't hide elephants in mouse holes, which is to say federal agencies can't claim massive new powers that weren't specifically given. This doctrine worked against President Biden on student loan forgiveness, public health, and the climate. And now it's Trump's government. This doctrine cuts both ways. So now the court has to decide. Are they going to apply it to the Trump administration? Or are they going to create loopholes that future Democrats can exploit? Now the court's going to hear a lot of major cases this term, but I want to focus on one. I'll cover birthright citizenship if they take it up, as well as Trump's federalization of the National Guard for immigration, and those lawsuits inevitably converge and arrive at the Supreme Court. Right now, though, I want to talk about tariffs, because this one is coming fast. And tariffs may be the best candidate for major questions doctrine I've ever seen, because imposing over $100 billion in new taxes on American businesses by increasing the average tariff rate by almost 20-fold obviously meets the threshold of vast economic and political significance. In fact, tariff revenue is already expected to surpass the cost of Biden's student loan forgiveness plan, and that was a case where conservative justices already specifically invoked the major questions doctrine. Now, obviously, these taxes were not authorized by Congress, but it's especially obvious through Scalia's metaphor, the elephant in the mouse hole, because these tariffs are imposed and collected by a federal agency. And Trump claims the right to impose these taxes on things like lumber, steel, aluminum, and upholstered furniture based on the claim there's an economic emergency because of immigration and trade deficits. But the IEEPA was passed by Congress and signed into law to give emergency powers to the president to freeze transactions with hostile foreign organizations, and specifically does not include references to tariffs, duties, or taxes, all of which are explicitly controlled by Congress thanks to the Constitution. To interpret the IEEPA in a way that allows import taxes on American businesses infinitely unlimited in their scale and duration is not just fitting an elephant in a mouse hole. It's fitting Donald Trump in a Speedo. And I think we can all agree, Supreme Court justice or otherwise, no one wants that.